This video is an overview of the Fair Wages and Healthy Families Act, specifically related to Arizona's earned paid sick time requirements. Please be advised that this presentation is provided for informational purposes only and does not constitute legal advice. The Arizona Revised Statutes and the Arizona Administrative Code remain the official sources for statutory and regulatory information regarding Arizona's earned paid sick time requirements. Proposition 206, the Fair Wages and Healthy Families Act, was a ballot initiative passed by voters in November 2016. The act modified Arizona's existing minimum wage laws and created the Earned Paid Sick Time requirements, also referred to as EPST. For the purpose of this video, we will review the EPST requirements of the act, which became effective on July 1, 2017. Throughout this presentation, we will share what the EPST requirements are, including which employers are subject to these provisions, the minimum accrual and usage of sick time, the notice, posting, and record-keeping requirements of the sick time laws, the penalties that may be imposed under these laws, and the protections in place for employees to exercise protected sick time rights. Under the Act, an employer for purposes of earned paid sick time is defined as any corporation, proprietorship, partnership, joint venture, limited liability company, political subdivision of the state, individual or other entity acting directly or indirectly in the interest of an employer in relation to an employee. Even small businesses that may be exempt from the minimum wage requirements are still subject to the Act's earned paid sick time requirements. However, Arizona's earned paid sick time laws do not apply to employees that work for tribal, federal, or state of Arizona. Under the EPST law, employees shall accrue a minimum of 1 sick time hour for every 30 hours worked. Employees who are exempt from the overtime requirements under the Fair Labor Standards Act will be assumed to work 40 hours in each work week unless their normal work week is less than 40 hours, in which case EPST accrues based upon that normal work week. An employer may allow a more generous accrual rate, but it cannot be less than the statutory minimum. This applies to all employees, including full-time, part-time, and temporary employees. The accrual of sick time begins upon the commencement of employment. Depending on the number of employees, the employer must allow them to accrue up to either 40 or 24 hours per year. If an employer has 15 or more employees, all employees shall accrue up to 40 sick time hours per year. However, if an employer has less than 15 employees, the employee shall accrue up to 24 sick time hours per year. If any of the 24 or 40 hours are unused at the end of the employer's year, the employer must carry over those hours to the following year. In lieu of carryover, the employer may pay out the unused EPST at the end of the year and provide a sufficient amount of EPST that is available for the employee's immediate use at the beginning of the subsequent year. Instead of using the accrual method, the employer may front-load all EPST the employee is expected to accrue in a year at the beginning of the year. The law also says that any employer with a paid leave policy, such as a paid time off or PTO policy, that provides leave that meets the minimum accrual requirements of sick time and that can be used for the same purposes and under the same conditions as earned paid sick time, is not required to provide additional paid sick time. Therefore, an employer may use a PTO policy to satisfy the Arizona EPST requirements as long as it meets these conditions. An employee retains and can use all previously accrued sick time if they are transferred to a separate division, entity, or location, but remains with the same employer. This also applies if a successor employer takes the place of an existing employer. Employees can use EPST as it is accrued, unless an employer has a policy that requires a 90-day waiting period before using any accrued sick time. EPST can be used for care for oneself or a family member's mental or physical health, injury, or illness, or for other medical needs. It can also be used due to a public health emergency closing a business or child's care, or for absences related to domestic violence, sexual violence, abuse, or stalking. EPST is provided upon the employee's request, either orally, in writing, electronically, or any other form acceptable to the employer. If the need for EPST is foreseeable, the employee must give advance notice and reasonably attempt to schedule it to minimize disruption to the employer's operations. If the need for EPST is not foreseeable and the employer requires notice, the employer must provide a written policy with notice procedures. If this written policy is not provided, EPST cannot be denied due to non-compliance with the notice requirement. EPST may be used in the smaller of hourly increments or the smallest increment the payroll system allows for other use of time. Reasonable documentation may be required only when an employee uses EPST for 3 or more consecutive workdays. Employees are not required to find a replacement worker as a condition to use EPST. An employer is not required to pay out accrued, unused EPST upon separation from employment, regardless of the reason, which may be termination, resignation, retirement, or other separation. Employers must provide written notice to employees covering their EPST entitlement and amount, terms of use, that retaliation is prohibited, the right to file a complaint, and contact information for the Industrial Commission of Arizona Labor Department. Employers are also required to post notices in the workplace informing employees of their sick time rights. The Arizona Labor Department's model poster can be used to satisfy this requirement. Employers must record the following on the employee's regular paycheck, physically or electronically: the amount of EPST available, the amount taken to date in the year, and the amount of pay received as EPST. This illustration provides an example of a regular paycheck that displays the necessary record-keeping details for EPST available, taken, and paid. Employers shall maintain records for 4 years, including time records with daily start and stop times, total hours worked, wages and sick time paid, additions or deductions to wages, and any written agreement used to calculate wages. An employer who fails to pay required EPST must pay the balance owed, interest on the original amount, and a penalty equal to twice the unpaid EPST. An employer cannot retaliate or discriminate against an employee for exercising a protected EPST right. It is unlawful to interfere with, restrain, or deny the exercise of any protected EPST rights. Retaliation under the Act is defined as the denial of any right guaranteed under the EPST law or any other adverse action as a result of exercising protected EPST rights. Adverse actions include, but are not limited to, termination, suspension, reduction of hours, being assessed attendance points, assigned unfavorable job duties, location or schedule, demotion, threats, or any other adverse action. Exercising protected EPST rights include inquiring about EPST, informing others of their rights, requesting or using EPST, filing a complaint, and participating in an investigation, appeal, or hearing. Employers who violate record-keeping, posting, or other EPST requirements face a civil penalty of at least $250 for a first violation and at least $1,000 for each subsequent or willful violation, and may be subject to special monitoring and inspections. Furthermore, any employer who retaliates against an employee for exercising protected EPST rights shall be required to pay the employee an amount to compensate them and an amount to deter future violations, but not less than $150 per day for each day that the violation continued or until legal judgment is final. This video provided an overview of the Fair Wages and Healthy Families Act, focusing on Arizona's earned paid sick time requirements. For more information, please contact the Industrial Commission of Arizona Labor Department.